on Government Order of the Day number 7.
Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill, second reading.
The Honourable Paul Goldsmith.
Mr Speaker, I move that the Patents, Trans-Tasman Patent Attorneys and Other Matters Amendment Bill now be read for a second time. The bill amends the Patents Act 2013 and includes a measure to build on Australia and New Zealand closer economic relations. The bill's key purpose is to provide a modern occupational framework for regulating patent attorneys. It achieves this by implementing a trans-Tasman licensing regime for Australian and New Zealand patent attorneys. I'd like to begin by thanking the Commerce Committee for its consideration of this bill, ably chaired by Melissa Lee. The committee's report includes several sensible recommendations for amendment to the bill. I want to also acknowledge the submissions from the public, and in particular from the patent attorney professions, whose submissions on the implementation of the single patent application process and the single examination process between IP Australia and the Intellectual Property Office of New Zealand assisted the committee to recommend deletion of Clause 5. When the single patent application and single examination process were first considered back in 2019, they were seen as having the potential to deliver benefits to innovative businesses by protecting their inventions through the filing of patent applications in Australia and New Zealand. It's now clear that as a result of the passage of time and the development of new international initiatives, implementation of the single patent application and examination processes is unlikely to be used by New Zealand businesses, and even if they were, not deliver a net benefit. With this in mind, I approve the committee's recommendation to remove Clause 5 from the bill. The chief purpose of the bill is to replace the 60-year-old and outdated regulatory regime for patent attorneys with a modern licensing regime. Patent attorneys are a small profession, providing specialist advice to businesses on the protection and exploitation of intellectual property rights. The current regulation of patent attorneys in the Patents Act is long overdue for an overhaul, as it falls well short of modern standards for occupational regulation. For example, currently there's no legislative requirements for them to behave ethically, to provide minimum standards of service, and to keep their knowledge of intellectual property law and practice up to date. There's no accessible means for redress for aggrieved clients of patent attorneys to pursue if their patent attorney has misbehaved. The qualifications regime, which requires a person to sit and pass a number of examinations, is outdated, inaccessible, and does not meet modern educational outcomes, consistent with the New Zealand qualifications framework, as set out under the Education Act of 1989. Because licensing regimes are expensive to implement and administer, our challenge in creating a modern licensing regime for the small patent attorney profession is to make it cost-effective. The bill achieved this by implementing, under Part 2 of the bill, a Trans-Tasman licensing regime for Australia and New Zealand patent attorneys. No, that's the SEM, that's a different part of the bill, which is largely based upon the modern licensing regime in Australia. The Trans-Tasman licensing regime is cost-effective because it takes advantages of the economies of scale that can be achieved by merging two similar licensing regimes in a single regime, and recognises that the majority of New Zealand patent attorneys are already registered in Australia and therefore are familiar and already complying with the Australian licensing regime. The Trans-Tasman licensing regime will provide a single register for patent attorneys, a single qualifications regime focused on Australia and New Zealand intellectual property law and practices, a Trans-Tasman IP Attorneys Board comprising of Australian and New Zealand members to oversee the qualification regime, maintain a Trans-Tasman Code of Conduct, and investigate complaints about misconduct and unethical behaviour of patent attorneys, and finally, a Trans-Tasman IP Attorney Disciplinary Tribunal to determine complaints about the behaviour of patent attorneys, and where appropriate, to suspend or cancel the registration of patent attorneys who misbehave. I do also want to take this opportunity to take a moment to address some of the concerns stakeholders expressed during the Select Committee. The first obvious concern was in relation to Clause 5, the inclusion of the single application patent process and the single examination process, which, as I've already touched on, we have done away with. Another concern was respect to the impact of the Trans-Tasman licensing regime for patent attorneys on competition between Australia and New Zealand patent attorneys. The Trans-Tasman licensing regime is indeed intended to facilitate more effective competition between patent attorneys and to make it easier for New Zealand patent attorneys to expand their services into the larger and more lucrative Australian market, and I back the New Zealanders to do well. Stakeholders expressed worry about an increase in costs for New Zealanders to qualify as patent attorneys. And there may be some additional costs, but many patent attorney stakeholders accept that the current regime is outdated and no longer fit for purpose. So implementing the Trans-Tasman licensing regime is the most cost-effective means to modernise the regulation of patent attorney services in New Zealand. Lastly, the availability of accredited courses of study in New Zealand to qualify for registration under the new Trans-Tasman licensing regime was another issue that was raised. If no courses are available in New Zealand, the concern is that students may be forced to take more expensive Australian accredited courses. But, Mr. Speaker, Victoria University's Law School is currently developing suitable courses of study for accreditation and expects to be able to start providing such courses from the beginning of next year, coinciding with the commencement of the new licensing regime. It's also important to ensure that the qualifications regime for patent attorneys is transparent and
you said finally.
Modern, pardon? Modern educational standards. Mr. Speaker, this is an important piece of legislation. This is achieved by requiring Australian and New Zealand students wanting to qualify as patent attorneys.
Point of order, the Honourable Clayton Cosgrave.
With respect, I think the Minister's making some salient points, trying to illustrate how a government had a position and then reversed it, and then reversed it again. And I think it's noteworthy in the House.
Thank you. It's not a point of order.
May I continue?
The Honourable Paul Goldsmith.
Mr. Speaker, we're a government that listens.
Don't start.
It's also important to ensure that the qualifications regime for patent attorneys is transparent and meets modern educational standards. This is achieved by requiring Australian and New Zealand students wanting to qualify as patent attorneys to take accredited courses of study offered by universities and other recognised education establishments. Mr. Speaker, this approach is no different to students wanting to qualify as lawyers, doctors, chartered accountants or architects. Now, Mr. Speaker, Part 1 of the bill implements a minor change to the grounds upon which a person may oppose the grant of a patent. As enacted, the Patents Act 2013 allows a grant of a patent to be opposed on the grounds that an accepted patent application claims patent protection for more than one invention. That is, the application, quotes, lacks unity of invention, close quotes. This is not a ground of opposition under the Patents Act 1953, and there was no policy intention to introduce this as ground of opposition in the Patents Act 2013. If the ground remains, patent applications may be unfairly disadvantaged by losing the patent rights to other inventions claimed in a patent application. The Commerce Committee has recommended that the amendment contained in this bill, which prevents a person opposing a grant of a patent on the ground that it claims more than one invention, be applied retrospectively back to the date of the Patents Act 2013 entered into force, namely the 13th of September 2014. Mr. Speaker, I do support the committee's recommendation on this matter, and I do commend this bill to the House.
Members, the question is that the motion be agreed to.